This is a review of BLLE Chapter 9, The Agreement. After reading the chapter, we should understand what a contract offer is, what a proposal is, how an offer is communicated, how definite the offer needs to be to form a contract, how long the offer is good for, how an offer is accepted, who can accept the offer, and when acceptance is effective. To have a valid and enforceable contract, there must be 1. Mutual assent, meaning that the parties must reach an agreement. 2. Consideration. 3. Legality of object, meaning that the agreement must be legal. And 4. Capacity, meaning that the parties must have entered into the contract of their own free will with knowledge of the facts and with capacity. In this chapter, we will cover mutual assent. Mutual assent refers to the agreement that the parties make on the same bargain at the same time. Mutual assent oftentimes is referred to as meeting of the minds. It is the process by which the parties reach a meeting of the minds, during which at some point one party makes a proposal, what we call an offer, and the other party will agree to that offer, what we call acceptance. So more specifically, mutual assent can be described as the coupling of an offer with acceptance. Basically, you can think of mutual assent as being a mutual understanding of what each party promises. Mutual assent means that the parties have agreed upon something and have prepared, to some degree, something to enter into the contract. A subjective meeting of the minds is not necessary to form a valid and enforceable contract. That means that we are not really concerned with what the parties think they did or what impression a party thinks they made. We are only concerned with the objective meeting of the minds between the parties. To form a valid and enforceable contract, each party must be held bound to the apparent intention they manifested to the other party. For this determination, we must focus on what the parties actually did and said. We will find that an agreement or mutual assent, absent more, does not form a valid and enforceable contract. We will go into this in greater detail later, but for now, you should understand what an offer and acceptance are generally. An offer is a promise, undertaking, or commitment with definite, certain, and seasonable terms that is communicated to the offeree by the offeror, which serves as the offeror's manifestation of the intention to be bound. Acceptance is just that. Acceptance of the offer, which must be made before termination by revocation, rejection, or by some other operation of law. Be sure to make a mental note that since we have 3 sources of contract law, i.e. case law, the UCC, and the CISG, there are essentially 3 different perspectives of what a contract is and whether it is formed. Depending on the circumstances, you must be able to apply one or more of these perspectives. As you are trying to figure out which law is applicable, consider the following questions. 1. Is the contract between domestic or international parties? And 2. Is the contract for the sale or transaction of goods? If the contract is international, i.e. between parties of different nation states that are signatories of the CISG, then you should apply the CISG unless the parties have agreed to the contrary. If the contract is domestic and covers a sale or transaction of goods, and there is a specific UCC provision that applies to the circumstances, then you should apply the UCC. Or if the contract is domestic and not for the sale or transaction of goods, or if the contract is for the sale or transaction of goods, but the UCC doesn't have an applicable provision, then you should appropriately apply the common law or the restatement view. So what is an agreement and what is a contract? Under common law, there is a difference. Common law defines an agreement as the manifestation of mutual assent by 2 or more persons to one another. Common law further defines a contract as a promise or set of promises for the breach of which the law gives a remedy or the performance of which the law in some way recognizes as a duty. The takeaway here is that an agreement does not form a legal obligation and a contract does. The UCC approach is different and slightly more complex. In the UCC, an agreement is defined as the bargain of the parties, in fact, as found in their language or inferred from other circumstances, including course of performance, COP, course of dealing, COD, or usage of trade, UOT. That means that if a contract is governed by the UCC, then courts may construe COP, COD, or UOT when determining the existence of a contract. Note that, like common law, no legal obligation flows from an agreement under the UCC. So what is course of performance and usage of trade, and what about this course of dealing? Each of these terms is defined in UCC section 1303. Pursuant to that section, course of performance refers to how the parties have been performing a specific contract in a particular way. It basically deals with the same parties and the same contract. For example, let's say we have a contract that provides for payment within 5 days of a particular event. The parties to the contract have always made and accepted payment within 5 business days of that event. So their course of performance shows that the parties intended the within 5 days term in the contract to mean 5 business days and not 5 calendar days. Next, there's course of dealing, which refers to a clearly recognizable pattern of previous conduct for the same goods as the subject matter of the same contract. Here we are dealing with the same parties and different contracts. For example, let's say the parties to this contract have had several contracts in the past for the same goods as are the subject of the same contract. Each of the past contracts has a particular term. If the parties leave that term out of the new contract, then it is likely that they will each intend the same term to prevail, but took it for granted because of past contracts. Here, course of dealing is probative to understand the current contract. Next, there is usage of trade, which basically sheds light on the parties' intention with regard to their current contract. Here, we are dealing with different parties and different contracts, but their intentions as it relates to an agreement may nevertheless be inferred. For example, 2 parties have experience in a particular trade. In that trade, a contract term has a particular meaning, or most contracts have that particular term. Here, even if the contract is missing this term based on usage of trade, the parties may have assumed that the specific term would be a part of the terms of the contract, and that term would be incorporated into the agreement. While determining whether there is an agreement, we use an objective test or standard and consider the reasonableness of the parties' words and conduct under the circumstances. We do not use a subjective standard which considers the mindset of the individual. If all of that is considered to determine whether an agreement exists, then what is a contract under the UCC? Under the UCC, a contract means the total legal obligation that flows from the parties' agreement. Now that we know what an agreement and a contract are, let's look at an agreement in closer detail. At this point, we know that mutual assent refers to the agreement. We know that an agreement is not a contract. So what is an agreement? An agreement exists if we have offer and acceptance. At common law, an offer is defined as the manifestation of an intent to be bound by the offeror that creates the power of acceptance in the offeree. For a manifestation or communication to be an offer, it must create a reasonable expectation in the offeree that the offeror is willing to enter into a contract on the basis of the offered terms. In deciding whether a communication creates this reasonable expectation, you should ask the following questions. 1. Whether there is a promise, undertaking, or commitment to enter a contract. 2. Whether there is certainty and definiteness in the essential terms of the communication. And 3, whether there is an actual communication of 1 and 2 to the offeree. If you answer yes to all 3 of these questions, then the offer creates a reasonable expectation to the offeree and manifests the offeror's intention to be bound. But we have some rules that we must follow for each of those questions. So, when determining whether there is a promise, undertaking, or commitment to enter a contract, the general rule is that mere invitations to begin preliminary negotiations do not count because the offeror does not manifest the intention to be bound by merely negotiating. There must be an actual manifestation of the intention to be bound to a promise, undertaking, or commitment. We can look to the language of the communication, the circumstances, the relationship or prior practice of the parties, and the method of communication to make the appropriate determination of whether there is a sufficient promise to substantiate a reasonable expectation and the existence of the offer. The language of the promise, undertaking, or commitment must show that an offer was intended. The phrases "I offer" or "I promise" are useful, but they are not always necessary in this determination. Phrases like "I quote" or "I am asking for" or "I would consider selling for" show that an offer was not intended because they are mere negotiations or invitations to deal. Advertisements, price quotations, and invitations to bid are not generally construed as offers unless they are definite and certain enough to overcome this general rule. The surrounding circumstances is another consideration to determine whether an offer exists. where there is a statement that is made in jest, anger, or by way of bragging, and the statement is reasonably understood in that context, then the statement will have no legal effect and will not create a reasonable expectation that the offeror manifests the intention to be bound. But where there is a statement that is subjectively intended to be in jest, and that statement is reasonably understood by the recipient to have been made seriously, then the statement constitutes an offer because it is interpreted objectively according to a reasonable person's expectations. Courts may also look to the prior relationship and practices of the parties involved to determine whether certain remarks constitute an offer or not. And another consideration is the method of communication. If the supposed offeror uses a broad communication media method, like a publication, for example, then it is more likely that a court will construe that communication as a solicitation of an offer and not an actual offer. Advertisements, catalogs, circular letters, and the like that contain quotations are usually construed as mere invitations for offers and not actual offers. The next requirement for a reasonable expectation is that the offer must be definite and certain in its terms. Here we must make a determination of whether there are enough essential terms provided so that a contract including those terms would be capable of being enforced. The offer must have essential terms with definiteness and certainty to create a reasonable expectation in the mind of the offeree. If we have an offer that contains alternatives and each of those terms are definite, then the offer is also definite. Even more, agreements in principle may be definite enough to rise to the level of an offer and create contract liability even if they lack many terms. As to certainty, the statement must sufficiently identify the offeree or a class to which the offeree belongs to justify the inference that the offeror intended to create the power of acceptance. As to definiteness, that depends on the subject matter of the offer. Essential terms vary with what type of contract we're dealing with. If we are dealing with a real estate transaction, then the offer is definite if it contains land and price terms. If we are dealing with a transaction for the sale of goods, then we know that the UCC would apply, and we would also know that the quantity term must be contained in the offer for the offer to be sufficiently definite. If we are dealing with employment offers and there's no duration term, then the offer and subsequent contract, assuming the offer is accepted, will be construed as creating a contract terminable at will of either party. And if we are dealing with an offer for services, then the nature of the work to be performed must be included in the offer. If there is a missing term, this does not necessarily defeat certainty and definiteness or prevent the formation of a contract if it appears that the parties intended to make a contract and there is a reasonably certain basis for giving a remedy or applicable external standard. In a majority of jurisdictions and under Article 2 of the UCC, courts can supply reasonable terms that are missing. If there is a vague term, this does not necessarily defeat certainty and definiteness or prevent the formation of a contract either. The presumption is that the party's intent was to include a reasonable term. The presumption cannot be made if the parties have included a term that makes the contract too vague to be enforced. So, for example, if there is an agreement to split profits on a liberal basis, then that's too vague to be enforced. But this uncertainty can be cured by part performance that clarifies the vague term or by acceptance of the full term. And if the parties include terms to be agreed upon later or at a future date, and that term is material, then the offer is too uncertain. Under the UCC, certainty and definiteness takes a slightly different meaning. Here, even though one or more terms are left open, a contract to sell will not fail for indefiniteness if 1. The parties have intended to make a contract, and 2. There is a reasonably certain basis for giving an appropriate remedy. Under this approach, if the parties intend to enter into a binding agreement, and if there is any reasonably certain basis to grant a remedy, then pursuant to Section 2204(3), that agreement is valid, even if it's missing terms. Also, if there are missing terms in a contract governed by the UCC, then the UCC has what we call gap filler provisions to supply those terms. Some of them are listed here. So, for example, if a contract is governed by the UCC and the price term is missing, then the UCC supplies the term and dictates that the price is whatever is reasonable. Or for example, let's say we have an output contract, which is an agreement wherein the seller of goods agrees to sell their entire production to the buyer, who in turn agrees to purchase the seller's entire output. Let's further assume that the output contract is missing a quantity term, or that the quantity term is vague, as a purchase of all output can be confusing. Then the UCC dictates that the output refers to the actual output of the seller that is not unreasonable and meets elasticity of demand requirements. Or for another example, let's say we have a contract for the sale of goods and it's missing a delivery term. Then the UCC dictates that delivery must be tendered in a single delivery and payment is due when delivery is tendered. And lastly, as it relates to the communication to the offeree requirement for reasonable expectation, to have the power of acceptance, the offeree must have knowledge of the offer. That means that the proposal, promise, undertaking, or commitment must be communicated to the offeree either directly or indirectly. So now that we have covered offer and acceptance, you should know that an offer can expire. If it does expire, then it will have an impact on the enforceability or existence of a contract. The following are ways in which an offer or acceptance may expire. Once an offer expires, it is dead and it cannot be revived. First, we have revocation. Under the common law and UCC approach, the offeror may revoke their offer at any time before the offeree accepts, even if the offer states that it will remain open for a specified period of time. Revocation is effective when it is received. Unless the offeror makes an offer inside of a newspaper or an advertisement, then the offeror can revoke the offer by using the same means they used to communicate the offer. For example, offeror communicates and offers to sell a car for $5,000 and promises to keep the offer open for 10 days to the offeree. Later, the offeror calls the offeree to revoke their offer. Here, the offer is terminated because the offeror revoked it. Thus, no contract is formed. Let's look at another example. Offeror communicates and offers to sell a car for $5,000 and promises to keep the offer open for 10 days to the offeree. Later, offeror mails revocation to the offeree, but before it gets to her, the offeree telephones acceptance of the offer. Here, the offer does not expire because the offeree accepts the offer prior to revocation, since revocation is effective on receipt. Thus, a contract may be formed assuming the other requirements are met. Another example. Offeror communicates and offers to sell a car for $5,000 and promises to keep the offer open for 10 days to offeree. Later, third party tells offeree that offeror sold the car to someone else. Then the offeree attempts to accept the offer. Here, the offer expires because the offeree received communication of the revocation indirectly. Thus, no contract is formed. Note that there are some offers that are irrevocable. Under common law, option contracts are irrevocable for the stated time. An option contract is one in which the offeror agrees to keep an offer open to the offeree for a stated time, basically so that the offeree has extra time to accept. We have not yet covered consideration, but option contracts must be coupled with consideration to be enforceable and limit the offeror's power of revocation. Another irrevocable offer is the firm offer under the UCC. The UCC essentially changes the common law rule for offers if it's made by a merchant. A merchant means a person who deals in goods of the kind or otherwise, by their occupation, holds themselves out as having knowledge or skill peculiar to the practices or goods involved in the transaction. So if we have an offer by a merchant that assures that the offer will be held open, then that offer must be evidenced in a signed writing to be irrevocable, i.e., form a firm offer pursuant to the UCC. There is no consideration requirement here. Also, firm offers must remain open for the stated period. If there is no stated period, then the UCC dictates that the period is for a reasonable time not to exceed 3 months. And there are some offers that are statutorily irrevocable or irrevocable by law. For example, in many jurisdictions, a contractor submitting a bid to a public agency cannot withdraw their bid unless the public agency or contracting authority consents pursuant to a statute that so mandates. The next way an offer may expire is by rejection. Rejection is the offeree's manifestation of refusal to agree to the terms of the offeror. Rejection is effective when the offeror receives it. If the offeree rejects and later changes their mind, this does not revive the offer. For example, offeror offers to sell their lawnmower to offeree. Offeree calls offeror to reject, then later changes their mind and calls offeror to accept. Here, no contract is formed because the offeree rejected the offer. The next way an offer can expire is by a counteroffer. A counteroffer is a response that varies the terms of an offer, which is basically construed as a rejection. For example, offeror offers to sell a parcel of land for $10,000 to offeree and states that the offer will remain open for 1 month. Offeree responds, stating that she will pay $5,000. The offeree's response constitutes a counteroffer, has the effect of rejecting the offer, and thereby switches the party's position. The offeree becomes the offeror. Let's assume the new offeree says no to the $5,000. Then no contract is formed because the second offer is rejected. But if the new offeree inquires whether the offeror will consider paying more, then the offer is still alive and the parties are negotiating. The next way an offer may expire is if acceptance is coupled with a counteroffer. For this one, it is important to note the difference between the common law and UCC perspectives. Under the common law approach, acceptance really doesn't count as acceptance if it is coupled with a counteroffer and it's treated as a counteroffer. An acceptance that varies the terms of the offer is a counteroffer and terminates the offer. The common law mirror image rule requires that acceptance match, i.e. mirror, the offer in all of its particulars. If acceptance does not mirror the offer, then the offer is rejected. Look at this example. Offeror offers to sell a house to offeree for $320,000. Offeree responds, I accept, but include the vacant lot next door. Here, the offeree accepts with a counteroffer and thus terminates the original offer. If, however, the offeree stated, it's a deal, and I'd also like the vacant lot next door, then the offeree's response would operate as acceptance and the request for the vacant lot is treated as a separate offer. Also, under the common law last shot rule, a party may implicitly assent and thereby accept a counteroffer by engaging in conduct indicating a lack of objection to it. Given the mirror image rule, every time a document is exchanged during negotiations, then it will be a counteroffer. If a party begins performance of the last counteroffer exchanged, that performance is interpreted as acceptance of the terms of the last counteroffer exchanged. So that means that the terms of the last document exchanged will govern disputes because it is the last shot. But what happens when we are dealing with more sophisticated parties, maybe one merchant or two, who have pre-printed forms that they use while they are selling and transacting goods? And let's say the offer and the acceptance don't match. As you may expect, the terms of the forms tend to favor the party sending the term. The drafters of the UCC thought the common law mirror image rule and the last shot rule were unfair, so they devised another way of dealing with this problem in Section 2207, or sometimes called the Battle of the Forms. Under 2207, additional or different terms in acceptance operate as offers, but they are automatically incorporated into any contracts between two merchants unless 1. The offer expressly limits acceptance to the terms of the offer. 2. The additional or different terms materially alter the contract. Or 3. A party notifies the other party that they object to the additional or different terms within a reasonable time. Take a look at this example. Offeror, a merchant, sends a purchase order for 100 widgets at a price of $20 per unit to be delivered on February 14th by UPS. In response, offeree, another merchant, immediately sends a written confirmation having substantially the same terms, except that the widgets may be delivered by any common carrier. Going through the 2207 analysis, we must first ask whether the offeree's acceptance created a contract. If there was not a definite, i.e. enough details, essential terms, stated price, and written confirmation, and seasonable expression of acceptance, i.e. within a reasonable amount of time, then there is no acceptance. Here, acceptance is definite as there are plenty of details, and it is seasonable because the offeree immediately sent the written confirmation. Since there is a definite and seasonable expression of acceptance, we must next ascertain whether the offeror created an express condition. Here, we are looking to see whether there is a condition in the offer that states that the additional or different term must be expressly assented to. If there is an express condition, then there is no acceptance and no contract. However, if there is no express condition, then the offeree accepted and we have a contract. In our example, the offeror did not create an express condition that if the offeree responded with an additional or different term, that they have to be expressly assented to. So the offeree's written confirmation operates as acceptance and we have a contract. So what happens to the additional or different terms? Which of these delivery terms will govern the parties' relationship? Well, that depends. If one of the parties is a non-merchant, then the terms of the offeror's form will govern the contract, and the offeree's acceptance form, containing the additional or different terms, will constitute mere proposals. If both of the parties are merchants, then the terms of the offeree's form will govern, subject to 3 exceptions, meaning that there is going to be no contract formed if one of these applies. 1. The offer expressly limits acceptance to the terms of the offer. 2. There is an objection to the additional or different term if notice of the objection is made in a reasonable amount of time. Or 3. The additional or different term materially alter the contract. A term materially alters a contract if it substantially changes the rights and remedies available to a party in the event of a breach, e.g., like an arbitration clause or disclaimer of warranty clause. Or if it substantially changes a material term, e.g., changes the price, quantity, or quality of goods to be purchased, or if it imposes an undue hardship or surprise. In our example, both parties are merchants, so the additional or different terms of the offeree's form will govern the parties' relationship unless one of those exceptions apply. Here, the offer does not expressly limit acceptance, there was no objection, and the use of a different carrier does not materially alter the contract. So the parties have a contract and the offeree may use any common carrier to deliver the widgets. If, however, at any point during this analysis, we would have said that there was no contract formed and the parties may have performed anyway, as though they had a contract, then we have to look at 22073. Since the parties performed anyway, then 22073 implies the existence of a contract by conduct, knocks out the conflicting terms, and uses all of those useful UCC gap filler provisions to fill in the blanks and define the obligations of the parties. See the next video for a continuation of our review on this chapter. If you have any questions, feel free to send me a message in Canvas or ask me after class.